right, joining us now to continue the conversation, criminal defense attorney Brian Claypool. Brian, thank you for giving us some of your time. So we just heard from Brian there in South Carolina. How big of a potential bombshell is this? I mean, are Murdaugh's lawyers grasping for straws? Is this, he said, she said, or does this hold some potential merit?
Hey, Nicole, great to be back with you. Make no mistake about it. This is a catastrophic legal explosion for the prosecutors. And if these affidavits are accurate, submitted by a couple of the jurors, I will tell you on your show right now, there will be a new trial granted without question. And here's why. Whenever defense lawyers petition for a hearing regarding juror impartiality, the presumption of the allegations being prejudicial is established, right, Nicole? And then the burden shifts to the prosecution to show, like Brian and Joe were saying, that it was harmless. But here's the kicker. This involves a county employee, the clerk of the court. So the level of prejudice and this presumption of prejudice at the hearing is even stronger because there is a court official involved. And the only way the prosecutors can conceivably not have a new trial granted if they say that, oh, Rebecca Hill talking to jurors, threatening jurors that if they smoke during deliberations that they'll be kicked off the jury, allegedly fabricating a Facebook entry to get a juror kicked off, that all of that is somehow harmless. And I will tell you right now that they'll never be able to establish this. And I believe that the trial court has no choice but to grant a new trial.
All right, so my next question for you, you started off your comments saying that this is a catastrophic legal explosion if it is all in fact true. Why do you think this is just coming out now?
Well, because defense lawyers didn't know that Rebecca Hill might have been talking to the jurors. It wasn't until, and by the way, being a defense lawyer, I would never think that as well. And in fact, Nicole, a few years ago, I almost had a mistrial in a criminal case because I said good morning to some jurors in an elevator. Just to give you an example about how sanctified this is, that lawyers, court employees are not supposed to be engaging with jurors. But let's get back to your question. I mean, if it's true that Rebecca Hill was telling jurors, for example, Murdaugh's going to take the stand. Don't believe anything he's going to say. It's what he's going to say is he's just trying to, defend himself. If it's true that Rebecca Hill went in on a Facebook post that wasn't legitimate, and by the way, there's evidence that she couldn't have even seen this Facebook post at the time she met with the judge. And then let's go one step further, Nicole. The judge in this case should be concerned as well, because he knew that Rebecca Hill had a dialogue with some jurors regarding this Facebook entry before she even came to him. He should have filtered that and vetted it. And then these comments to jurors, if it's true about you can't take a smoking break until you reach a verdict, that's going to be construed as undue duress placed on jurors by a top court employee.
All right, my last question for you, Brian. Let's fast forward here. Let's say that Murdaugh is, in fact, granted a new trial. We don't know whether or not he would be found guilty or innocent, but we know he is facing many other legal proceedings. How do you think, if he's granted a new trial, how would that potentially impact his future legal proceedings in his numerous other cases?
Well, if Murdaugh gets granted a new trial, what I would do if I was defending him is immediately file, again, a motion to sever or to suppress any communications about the financial crimes and the ongoing proceedings involving the financial crimes. Personally, I felt like the judge maybe should not have allowed all of that in the first trial. That's the first thing I try to do, segregate everything, focus just on the murder trial. And then in terms of strategy, I mean, if there is a trial too for Murdaugh, which I think there will be, he is going to have to take a different position and come forward in the case and admit that he was at the dog kennel, not try to make up some kind of excuses or lies. But here's the problem, Nicole, real quick, on trial number 2 for Murdaugh. All the testimony and evidence generated in trial 1 can be used for what's called impeachment evidence in trial too. So anything Murdaugh said, anything other witnesses said, if they try to change testimony, lawyers and prosecutors can pull that testimony from trial one, use it to impeach him in trial two. So he still has a daunting task ahead of him, even if he gets a new trial.
Yeah, certainly. This really has been such a fascinating case, and to think that it could continue is so interesting. All right, criminal defense attorney Brian Claypool, thank you for your time.
Yeah, thanks, Nicole.